Welcome to INAN's Student. INAN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Divyanshu Joshi. He is going to speak on Memorandum of Association and Prospectus under the Companies Act 2013. He is from KES Shri Jayantilal H. Patel College of Law. So without wasting further time, I would request him to commence with his lecture. Thank you.
Greetings to everybody. My name is Divyanshu Joshi and I am here to tell about the two important pillars of the company law, that is Memorandum of Association or MOA and the Prospectus. It is not just legal document but they are the blueprint of the company. Memorandum of Association define what a company can do or not do. Prospectus is how a company invite the public to investigation, ensuring transparency and the trustee. I will cover the structure and the alteration of the MOA and move to the types and essentials of the prospectus. MOA. What is an MOA? So let us understand. Imagine a group of people coming together to start a business for a special purpose, usually to make a profit. To make it officially, they file an application with the registrar of the company. And one key important document is MOA. Is defined under section 2 subsection 56 of the Companies Act 2013. It is a public document. So anyone who wants to deal with the company can go to the ROC, that is registrar of the company, and take it by paying a prescribed fees. That is under section 399 of the Companies Act 2013. Now there are total 5 forms under the schedule 1 of the Companies Act 2013. Table number A is if share end up limiting a company, B is if a guarantee limit a company, C is if a guarantee along with the share capital D limiting a company, D is if it is an unlimited company, E is if it is an unlimited company and has a special share capital. Now we will go to the what are the context of the MOA. First is the name clause. If the company is starting from the if the company is the public company, then word limited must be there in the name of the company, and if it is the private company, then private limited must be there in the company. The name of the company cannot be identical or similar to existing one. Means if the company is name is the Green Tech Solution Limited, then another company cannot make of that name. And if we are using the word government, then it is not valid, because if we are not affiliated with the government and if it is not government company, then we can not use the government company. And now we will next go to the reservation of the name. We can advance reserve the name for the 60 days by filing an application to the ROC. If we are submitting any wrong documents, then there is fine up to 1 lakh. Now we will go on the next clause, that is register office clause. To fix the nationality and the court jurisdiction of the office, it is necessary to have a register office. Pre-incorporation just name are stated, but after the post-incorporation, within the 30 days of the from the incorporation, the company have to make it permanent residence office, and outside it he have to mention the name and address of the. If one person company is there, then below the address he have to mention that it is a one person company. Next clause is the objective clause. It is the heart of the MOA. It is the main objective that help the shareholders and creditors and public interest to know about the companies, and it help the shareholder to knowing where their monies are going by the objective clause. Objective clause is basically that what are the company will do and what they will do further. If company are going beyond the objective clause, then it is ultra vires and it is void. There is one case law, Asbury Railway Carriers versus Richard. In this, the Asbury Railway Carriers is main objective is to make the railway compartment, but they enter into the contract of making the railways. It is void because their main objective was to make the compartment of the railway, not making the tracks, because that is ultra vires and it is void. Next clause is liability clause. Liability clause is divided under 3: limited by share, limited by guarantee, and unlimited liability. Limited by share are the paid only unpaid share amount. Means if they are taken any share and if there are unpaid amount, then they are liable for that only. Next is the capital clause. Capital clause state the amount of the capital which the company is to be registered and how much dividend of the share will be there. Next is the 1% company. If it is a 1% company, then nomination clause is necessary in the MOA of the 1% company. Next is the alteration method. For changing of the name, there must be special resolution plus central government permission. If we are adding or deleting word public or private, then central government permission is not necessary. And then after, form ICN 24 to the register of the company. And if we are changing the office residence office address, then we have to take permission from the central government. Then we have to take the special resolution, and government have, and within the 16 days stakeholder consent within the 60 days. Next is the objective clause. For changing the objective of the company, it is necessary for special resolution. In this, central government permission is not needed, but after changing the objective clause, we have to publish into two newspapers. One is the local, in which the state is there. If a company is of Maharashtra, then one in Marathi and one in English, and they have to also publish into the website of that company. Next is the capital clause. For changing of the capital clause, ordinance resolution is passed. No special resolution is required. Now we will go to the prospectus and types of prospectus. Prospectus, when does company issue it? To raise public fund, transferability. Section 270 of the Company Act 2013 define the prospectus. What is the meaning of the prospectus? It is an invitation to offer, providing essential info on finance and purpose. Public bidding within a price band company allot as fit. Purpose: inform investor for decision. For retail, it virtually promote governance through transferability. What are the essentials? Prospectus cannot be in oral. It must be in the written, and it is invitation to public. It must be invited by the company, not any other person or person can be invited. It is by company only, and must be issued to general public only or any classified public only. What are the types of prospectus? First is the self prospectus. If the company is issuing multiple time of the share, then they issue the self prospectus. It is valid for 1 year. And second is the red herring prospectus. It is not full-fledged prospectus, but in this no price or quantity is given. It is basically this prospectus is issued for the knowing the interest of the people, that they are interested into the company or not. Next is the deemed prospectus. A company does not directly sell it to the public, but instead give the share to the someone else like a bank or underwriter. In the deemed prospectus, the company is not issuing its issuing share, but they are hiring someone to issue the prospectus like bank, or they are taking the underwriters. What are the misstatement? If we misstatement in the prospectus, civil is section 35 is given. Liability for losses if material and known, remedy like decision. If we are giving any misstatement in the prospectus, then section 35 it is civil liability, and we have criminal liability also, that is section 34. In criminal liability, that is 6 months, minimum 6 months and a maximum 10 years of jail plus fine. If it is public interest litigation, then minimum is 3 years. When prospectus need not to be issued, if we are if there is an underwrite agreement or giving to an existing shareholder or private offer, then the underwriter cannot be issued. So I like to conclude that MOA and the prospectus are the two important. MOA is during the incorporation of the company, and prospectus is for the issuing of the fund. Thank you so much.
Divyanshu, thank you very much for giving a nice overview of Memorandum of Articles and Prospectus. This is a small token from Hammurabi to you.